है ना, अब दिख रहा है देखो। हमारा फोन आ गया तो सब कुछ दिखेगा। किसका फोन था? श्रुति का? अच्छा, चलो शुरू करो। हेलो फ्रेंड्स, गुड मॉर्निंग एवरीवन. In Prelims support program today, we will talk about some new topic in polity, and we have discussed historical background of Indian Constitution and few questions on historical background. Yesterday we talked about preamble and basic concepts in political philosophy of Indian polity, and we also discussed few questions. Now today we will take up fundamental rights, which is an important part. From this part, if you see, UPSC asks question every year, sometimes 2 questions, sometimes 3 questions, sometimes 4 questions, right? So this part is very, very important in order to prepare polity for prelims 2024. So let's see what are the questions, which question and what are the concepts that are actually important. So today we will do this by doing or solving questions. So let's see the question. Yeah. So the first question is, in the context of equal protection of law, consider the following statements. Now it has US origin. It means equal treatment in the eye of law. It ensures absence of any privileges, right? So there are 3 statements. Now let me talk about equal protection of law. Fundamental right. Let me talk about fundamental right, and before fundamental right, let me talk about rights. Rights is a claim against the state. It is a claim of individual. It is a claim of individual against state, right? This claim may be against society, claim against family, claim against collective body. So here it is an individual right. Individual is very important in understanding liberal constitution, right? So if you look at, that is a right. Now fundamental right, if you look at fundamental right, we have 6 set of fundamental right, and first set is right to equality. And here you have article 14 to 18. Now article 14 basically discusses about right to equality. If you look at article 14, talks about that equality before law and equal protection of law. Equality before law and equal protection of law. Now what is equality before law? Now if you see, equality before law has taken from British jurisprudence or British law, and equality before law is an essential part of rule of law, right? Essential part of rule of law, which means that all individual, irrespective of sex, religion, caste, creed, ethnicity, all are equal before the law or in the eye of law, and there is no special privileges, right? There is no special privileges, and all are equal before the law, and the law shall rule, not the executive power or the another arbitrary power. Law shall rule. So the rule of law also means absence of external or arbitrary forces, right? The law shall rule, not the person, not the any executive body. There should be law and that rule that will govern the society, right. Now, if you look at, that is equality before law. Now, here come to the equal protection of law. Now, equal protection of law has not a US origin, it has British origin, oh sorry, it has US origin, right. Equality before law has UK origin, equal protection of law has US origin, and it says that that all shall be treated according to their circumstances. Now, each community will be treated according to the circumstances, the socio-economic background, right. So, there should be equality, equal should be treated equally and unequal should be treated unequally. So, here it is a basic positive concepts, because women should be treated like women, or children should be treated as children, or tribal should be treated as a tribal, or first killer, though someone has killed first time, right, by mistake, but if someone is a serial killer, now serial killer would be treated differently than the first time killer. So, here equal protection of law gives protection of law, right, to each individual in a particular circumstances, particular context, and therefore, basically equal protection of law discriminate positively, it discriminates positively, right. For example, for children there is a less harsh punishment, right, there is a less harsh punishment. For the serial killer there is a harsh punishment, the first time offender less punishment. Now, come to, so you can find equal protection of law has US origin, and it means equal treatment in the eye of law. No, that is a basic concept of rule of law. Now, it ensures absence of any special privileges. Now, rule of law ensures absence of any privileges. So, this is also incorrect. So, question statement 1 is correct, and that is, then answer would be A, right. So, here we talked about two basic terms which is used in article 14, that is equality before the law and equal protection of law. Equality before law is an essential part of rule of law which has been taken from Britain, right. On the other hand, if you look at the equal protection of law, it has US origin, and basically it discriminates, right, individual, it gives positive discrimination, it gives affirmative action, right, it gives actually takes sense of circumstances and socio-economic background of individual while treating or while applying law on them, right. So, that is, now move to the next question. Now, look at, in the context of right to equality, consider the following statements. Now, the right to equality. Now, always keep article 14 to 18 in your mind. Always keep article 14 to 18 in your mind, right. And here article 14 is a core article to the right to equality. Yes, if you look at article 14, actually establishes the rule of law, which is basic structure of the Indian Constitution. Let me tell you, the rule of law, right. And it also talks about equal protection of law, equal protection of law, right. Now, where article 31C comes, article 14 goes out. Now, look at article 31C. What it is, basically what does it say? Article 31C gives priority to DPSP, and if you look at 42nd Amendment Act, right, or if you look at before this 24th CAA of 1971, right, 42nd CAA of 1976, both Amendment Act actually prioritized DPSP over fundamental rights. So wherever state make policy for for welfare of the deprived people, then we the common citizen of India cannot call for equality, cannot claim equality. So wherever 31C comes, Article 14 goes out. Article 15C and Article 16, Article 15 and 16 of the Constitution ensures equity. Yeah, it is, basically it is, because if you look at the major part of Article 15, Article 15 clause 3, which actually gives a special protection to children and women, right? So it gives protection to, a special provision to children and women, right? If you look at Article 15 clause 4, which gives a special protection to SCs and STs, right, and also socially economically backward classes, right. Then Article 15 5 and 6 gives a special protection to EWS. Similarly, if you look at Article 16, it also gives a special protection to scheduled caste, scheduled tribe, right. Especially if you look at Article 16 clause 4A, which actually provides reservation in promotion. So if you look at Article 15 and Article 16 clause 4 of the Constitution ensures equity. So this is correct, this is also correct, and this is also, first one is also correct. So you can see all statements are correct. D would be the correct answer, right. Let me move to the next question. Now look at the third question here. With reference to right to equality, consider the following statements. Where equals and unequals treated differently, Article 14 does not apply. Where equals and unequals treated differently, for example, let me talk about what is Article 14. Article 14 has two basic terminology: equality before law and equal protection of law. Right? Fine. Now come here, where equals and unequals treated differently. For example, BPL people or SCs people, right, or STs people or LGBT QIA plus, they have been treated differently because they are unequal, right. So when equal and unequal treated differently, equal and unequal article does not apply, right. So this is correct. Now it is an essential feature of the Indian Constitution. What? Article 14, right to equality. Yes, it is a essential feature, but not all are essential feature. So we can say that this is not correct, right. It can be abrogated under Article 368. Which of the state? Yeah, right to equality can be abrogated Article 368? No. Now if you look at because rule of law is a basic structure of the Indian Constitution. So rule of law cannot be abrogated, right. Now if you look at the statement 1 and 3 is correct. So B would be correct answer of this question. Look at Article 14 is very, very important for your prelims. Now look at the next question. In the context of the fundamental right, consider the following statements. Now it is talking about entire fundamental right. Entire fundamental right. Now it is a set of purely positive rights. Now look at, I told you that, let me explain one thing. If you look at rights, rights is a claim. I told you that it is a claim of individual, claim of individual. Now, if you see, entire rights had been divided into two parts. This entire rights had been divided into two parts, right? First part was kept in fundamental right and second part was kept in DPSP. Now, in DPSP all are positive rights. Now, why it is called positive rights? Because the DPSP requires a state intervention, right, so that people can understand the true meaning of rights. The true meaning of rights. Now, fundamental rights, if you look at, there are certain negative rights. Certain rights are negative rights. For example, Article 21, right to life and personal liberty, right? A state cannot take it away, right, even during the emergency. Article 21 cannot be taken away by the state, right, and the state has obligation to protect Article 21. It cannot take, right. So, it has negative rights like Article 19. A state cannot snatch right to freedom of speech and expression. Otherwise, the life cannot be called, the dignified life. If you remember Ramesh Thapar case, in which Supreme Court said, right to freedom of speech and expression is an essential part of democratic life, essential part of Indian Constitution, right. So, basically Article 19 is also part of negative right. Now, if you look at, certain rights are positive, for example, and that requires a state intervention so that individual can enjoy better. For example, Article 15 clause 1 and clause 2 is a negative right. Now, if you look at Article 15 clause 3, it is a positive right, because a state is intervening, right. A state makes a special provision for children and women. So, Article 15 clause 3 is a positive right, Article 15 clause 4 is a positive right, Article 15 clause 5 and clause 6 all are positive right. So, you can see fundamental right is a set of negative right as well as positive right. For example, Article 21 is a classical example of negative right. But if you look Article 21A, right to education. Now, right to education is a basically positive rights. Now, focus on the question. In the context of fundamental rights, consider the following statements. First, it is a set of purely positive rights. Fundamental rights are purely positive rights? No, there are negative rights also. Article 21, Article 19, Article 14, equality before law is a negative right. Then Article, right. So, this is wrong. Right to life is a natural right as well as a fundamental right. Yeah, right to life is a natural right, right. Right to life is a natural right. Now, second, there are few rights which are reserved only for citizen. Yeah, if you look at, few rights are reserved only for citizen. What are those? If you look at Article 15, Article 16, Article 19, Article 29 and Article 30. These 5 articles are especially dedicated to citizen of India, right, and the rest article can be available to all, right. So, these 5s are only for citizen. These rights are only for citizen, but the rest other rights are available to all, non-citizen and as well as citizen. Fine. So, if you look at here, right, statement 2 is also correct. So, this is not correct, it is a set of purely positive rights, no, and then this is correct, right, this is correct. and this is correct. So 2 and 3 both are correct. 2 and 3. 2 and 3 are correct. So fundamental rights are not a set of is not a set of purely positive rights. It is a positive right. It has positive rights also negative rights. There are few rights in the fundamental rights which are actually secured for citizen only. Yeah, that are 5 articles are especially dedicated to Indian citizen, right? Now, right to life is a natural right. Yes, right to life is a natural right. Now, how will you define right to life? Let me tell you, right, what is natural right. If you look at rights, and if I divide rights, so there are several evolution of right. Right is a modern concept, right? The concept of rights was not there in the ancient time or even in medieval time. Right is a modern concept, right? Evolved in 17th century, right? With liberalism. If you look at rights, rights evolve with liberalism. Rights is a basic essential feature of liberalism and liberal political order, right? And the first set of rights actually talk about natural right. Now, what is natural rights? Now, individual has a set of rights by birth, because nature has given birth. So, nature has also given some inalienable or inseparable rights. Now, what are those? For example, right to life. Right to life is a natural right, or right to work is a natural right. Right to speak, right to cry. Right to cry is a natural right. Right to sleep. It's a natural right. So, by birth, actually, right to eat. So, by birth, if you look at, there are several rights the individual acquires by birth, right? No one has a right to take life. Even parents have no right to take the life of the particular individual, right? So, this is a natural right. So, if you look at this, all natural rights are also fundamental rights. If you look at, right, what is fundamental right? The certain rights have been recognized as a fundamental, as a essential to live a dignified life, to live a democratic life, a human life, a dignified life, and that is called fundamental right. Right. Let me explain next concept with the next question. Now, look at the question here. Which of the following has not been included in right to life? Here, Article 21 is right to life, and question is, what is not included? Now, look, right to live with dignity, is it part of Article 21? Yes, it is part of Article 21. Right to life includes right to live with dignity. Right to road in hilly areas, yeah, because if you look at hilly area, life has become very much difficult, right? There is a lack of roads, and without lack of roads, there is no right to walk, right? People faces lots of hindrances, and then Supreme Court has defined that right to road in hilly area is a essential part of Article 21. Right. So, even Article 21 has been expanded by the Supreme Court. So, right to road in hilly area is a part of right to life under Article 21. Now, right to sleep, what do you think? Right to sleep. If someone has no right to sleep, can he or she enjoy right to life? No. So, right to life is essential part, right to sleep is also part. Now, right to move freely without any restrictions. Now, we have right to move freely, but there are some restrictions. For example, in ecological sensitive area we cannot go, in military area, right, where security concerns are there, we cannot go, right. So, there is a, if you look at right to free movement, right to movement is discussed in article 19, right, and it has certain restrictions, right. So, this is not had been included. So, D would be the correct answer. Let me move to next question. Now, question is, right, it is a very long question. Look at, in the context of right to protest, consider the following statements. Here concept is right to protest. The United Human Rights Committee has declared right to declared protest to be a fundamental human right under the International Covenant on Civil and Political Rights. Let me tell you, this International Covenant on Civil and Political Rights declared by United Nations in 1966, right. It is declared by United Nations in 1966, and that actually was called International Covenant on Civil and Political Rights, and that recognized right to protest as a right. So, first is correct. Now, India is not a party to the International Covenant on Civil and Political Rights. Let me tell you, India has rectified, India had rectified, India has signed the treaty, signed the resolution. So, not a party, then it is wrong. India is a party to the International Covenant on Civil and Political Rights. So, see the third, the Constitution guarantees the right to protest and express dissent against action or inaction of the state. Indian Constitution gives such. So, 1 is correct, 2 is not correct, 3 is correct. Let us see 4. Reasonable restrictions can be imposed in the interest of sovereignty, integrity and public order. Yeah, this is also correct. If you look at article 19, there are restrictions. So, 4 is also correct, right. 2 is not correct, because here it is written India is not a party to the International Covenant on Civil and Political Rights, but India is a party. So, 1 and 4, 1, 3, 4 you have to choose. Look, see, C is correct answer of this question, right. Let us see, let us move to the next question. Now, look at which one of the following provision is not considered as an element of principle of natural justice. Now, this is a big question, right. Natural justice. Let me, natural justice. Now, what is natural justice? Natural justice implies that there should be fair justice. So, first thing, there should be fairness. Natural justice is actually concerned with fairness, right. Now, what is fairness? Now, you should judge. Now, you should, everyone can judge what is fairness, what is not fairness. Now, if you understand fairness, then now let me read the statement. No one can be judge of his or her own case. It means no one can be judge of his or own case. Now, consider A is a person who is accused of harassing, sexual harassment. A is a person, right, but he is also judge of the Supreme Court. Consider he is also judge of the Supreme Court. Can he, and there is an accusation against A. Can A sit against his own judgment? Right? No. Right? No one can judge, or no one can be judge of his own case. Right? So, I think this is correct. So, this is a part of the natural justice, right? Because if A would sit in his own case, that would be not just thing. So no one can be judge of his own case, correct? No one can be judge of his or her own case. उसमें जज नहीं होना, जज कोई और होगा, right? So it is correct. Yes, it is correct. It is an essential part of natural justice. It looks like fairness. It looks like fair. Now, no one can be punished unheard. Can judge punish a person without listening? It also seems it is not fair. We should listen, or a judge should listen. Each party provides equal opportunity and sufficient time so that each party can argue or advocates, right, for their case. So every party should be heard. So no one can be punished unheard. It is also correct, right? So no one can be punished unheard. It is also correct, right? No person can be denied information on the grounds of which he is or she is arrested, right? Here is the case. Now look at the fourth. No authority shall act in a biased manner. No authority. Can authority may act in biased manner? Right? Can judge be biased? No. Non-biasness is also fairness. Right? Now, no person can be denied information on the grounds which he can be arrested. Now, sometimes it happens. Now, consider when there is a case of terrorism, right? When there is a case of terrorism and police actually arrest randomly people without being, giving information, right? Without giving information. So, if you look at the C may not be the essential part of natural justice, right? So, natural justice means fairness. If you think something is fair, that means natural justice is done, right? Now, let us see the next question. The next question look at, with reference to rights of citizen of India, consider the following statement. Rights of citizen. Now, rights of citizen. Now, right to reservation in appointment and promotion in government job is implied fundamental rights. Right to reservation in appointment and promotion in government job is implied fundamental right. Yes, right. Now, right to maternity benefit is implicit in fundamental rights, Article 15 clause 3, explicit in directive principle of state policy. Yeah, Article 42. Yeah, I think Article 42. Right. So now here you see article statement 1, right to reservation. Reservation कहीं लिखा नहीं है कि reserve, right? ये implied ही है, right? So I think right to reservation in appointment and in promotion in government job is, implied fundamental rights, right? Correct. Right to maternity benefit is implicit in fundamental right and explicit in directive principle. Yeah, so both are correct. C would be the correct answer, right? Now let me move to the next question, right? Now question is, which of the following judgment of the Supreme Court declares secularism as a basic structure in the Indian Constitution? Which of the following judgment declares secularism as a basic structure of the Indian Constitution? Now you see, S.R. Bommai case is a famous case of 1994, which declares, secularism, federalism, right? These all are the basic structure of the Indian Constitution. So, C would be the correct answer. Look at question number 6. Next question. Which one of the following is not correct about reservation of the economically weaker section of the society? Which one of the following is not correct about reservation for the economically weaker section of the society? Not correct, right? P.V. Narasimha Rao government has provided for the first time, it is correct. The 103rd amendment to the constitution made provision for it, it is correct. Persons whose family income is less than 8 lakh can avail it, yes, correct. It was passed during the Manmohan Singh time, no, it was passed during the present Prime Minister, Mr. Narendra Modi, right, in 2019, right. So, this is not correct. So, D would be the correct options, choose. Now, look next question. See, in the context of right to freedom of speech and expression, consider the following statement. In the context of right to freedom of speech and expression, consider the following. It is only available to Indian. Now, here I told you that there are certain fundamental rights which are available to Indian citizen, and Article 15, 16, 19, 29 and 30. You should remember this. There are 5 articles which are actually given to Indians only. So, you can see this is correct. It is suspended automatically whenever national emergency is declared. Yeah, it is suspended automatically whenever national emergency is declared. Right to form cooperative society is a fundamental right. Yes, this is also correct. 1, 2, 3, all are correct. D would be the correct answer. Look at the next question. With reference to reservation in jobs and educational institution, consider the following statements. The total reserve quota should not exceed 50% in some, except in some extraordinary situation. Yeah, this is correct. And you all know that the judgment given by the Supreme Court in Mandal case, Indrasani versus Union of India case, where Supreme Court has given that the reservation should not go beyond 50% except in certain exceptional circumstances. So, this is correct. Now, 76th amendment to the constitution placed Tamil Nadu Reservation Act in the 9th schedule. Yeah, this is correct. Tamil Nadu provides 68% reservation, and that law is placed in a 9th schedule, right, and which is protected. Judiciary cannot judiciary cannot do over judicial review on it. Ramanandan committee was appointed to identify reservation for Muslim community. No, it was Ranganathan Mishra committee, right? It was not Ramanandan. So, 1 and 2, P would be correct answer of this question. Let me move to next question. Look at the question. Consider the following statements. Right to freedom and speech in unlimited in Indian democracy. तो ऐसे लग रहा है गलत है. Right to freedom of speech and expression is unlimited. No, it is restricted. So ये तो अपने आप गलत हो जाएगा. Indian has unrestricted right to move freely throughout territory of Indian state. No, this is also correct. Incorrect. So both are incorrect. Unrestricted कुछ भी नहीं है. Constitution put limitations, right, on freedom of movement as well as freedom of speech and expression. Let me move to next question. Look at this question. Which of the following practices are prohibited under Article 23 of the Indian Constitution? Selling or buying of man, woman and children, Devdasi system and forced labor, all of the above. Very easy question. Under Article 23, if you look at, these all are prohibited, right, under the Indian Constitution. Now look at the next question. In the Indian Constitution, which one of the following does not explain the term beggar? Work without remuneration, involuntarily work without payment, labor for which the worker receives less than the government's stipulated minimum wages, state assigned compulsory work. Which does not term explain the beggar? Now let me tell you state assigned compulsory work. For example, tomorrow state may do compulsory for military training. That it cannot be called beggar. Otherwise, all three terms actually explains the term beggar, right? So basically, D would be the correct answer. Now look at Article 20, this question. One of the implications of equality in Indian society is the absence of restraints, competition, ideology, privileges. There is an absence of privileges, right? There is no privileges on the basis of caste, on the basis of creed, on the basis of ethnicity. All are equal. Fine. Now look at the next question. Here we can find out, yeah, right to vote to be or right to be elected in India is a fundamental right, natural right, constitutional right or legal right. What are that? Is it fundamental right? No. Is it natural right? No. Right. Then is it constitutional right or legal right? Let me tell you this, both, but you have to click C, because where legal and constitutional is there, and both options are correct. Let me tell you, both options are correct, right? You have to put C, because Constitution talks about that no person shall be discriminated for enrolling the voting in electoral roll. But at the same time, if you look at the Representation of People Act, RPA Act 1951 also talks about the vote. So your answer would be C, correct options. Now let's see few questions. Yeah, see this question we can be identify. Oh, there are some part this side, some part that side. Now look at question number, this question. Which of the following are envisaged by the rights against exploitation in the Indian Constitution of India? Which of the following are envisaged by the right to against? Now, prohibition of traffic in human being and forced labor, no, Article 23. Abolition of untouchability, no, Article 17. Protection of interest of minorities, no. Then I think last. Prohibition of employment of children in factories and mines. The provision of employment is there, or mines, but there is no single. So let's see, there will be another. Prohibition of traffic in human being and forced labor. Right against exploitation, the Article 23. Yeah, so this is also correct. One. This is Article 17, जो right to equality में आता है, और protection of interest of minority. This is Article 29 and 30. So right against minority. So one is also correct here. So 1 and 4 tha na, 1 and 4, yeah. He would be the correct answer, right, for this question. Let me see the question number 27. Which one of the following statement is correct? Right are claims of the state against the citizen. rights are claim of the state against citizen. No, it is a rights are claim of individual against the citizen. Rights are privileges that are incorporated in the constitution. No, rights are not privileges. Rights are claims of citizen against the state. Yeah, rights are claims of citizen against the state. Now look at the D statement. Rights are privileges. No, rights are not privileges. So answer would be C. Rights are basically claims of individual against state, against collective body, against society, because it is of individual, not the society, right. So C would be the correct answer. Now look at article this question, right. It would be 30. Now right to privacy is protected as an intrinsic part of right to life and personal liberty. Right to privacy is protected as an intrinsic part of the right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately apply the above statement? Article 14 under no, Article 17 no, Article 21, yeah, Article 21. Right to privacy is guaranteed article under Article 21. Remember Puttaswamy case, Puttaswamy versus Union of India case, where the right to privacy is declared as an integral part of right to life under Article 21. Now look at article this one, the 31st question. Which one of the following reflects the nicest appropriate relationship between law and liberty? Which one of the following reflects the nicest appropriate and relationship between law and liberty? Law and liberty, right. So who should be the minimum? Let's see. Law is necessary for the liberty, otherwise liberty becomes license, right. Anyway, let's see, if there is a more law, there is a less liberty. Statement is correct, but relationship is not so good, so nicest. Let's first read all. If there is no law, there is no liberty. It's true. If there is no law, there is no liberty, right. We need law so that each individual can enjoy liberty, right. Otherwise what happens? Individual claims liberty as a license, right. They want to actually walk on the main road, right, or people park their vehicle where they should not park, right. So if there is no law, there is no liberty. If there is a liberty, law have to be made by the people. No, but if law are changed too often, liberty is in danger. Now look at the B would be the correct answer, right, the more appropriate, right. However, if you look at all four reflects, this should be correct, this should be correct, right, either A or B or C or D. Now B would be the more appropriate answer, right. Now look at which one of the following are regarded as the main feature of rule of law. Now look at the rule of law. I told you that rule of law has for certain feature. What is the feature? Absence of arbitrary power. There is no absence of arbitrary power, right. So there is a limitation of power. What does it mean? Limitation to power. Power should not be absolute, power should be limited, right. So limitation of power would be correct. Now equality before law is also equality before law is a essential part, yes. People's responsibility to the government, it does not. No, rule of law does not implies people's onus, people's duty, people's responsibility towards the government or towards the society. No, Now, liberty and civil rights, yeah, there are rights. Rights are important, rights of individual actually are important, right? And rights are sacrosanct until individual does not violate the law, right? So, rights and if you look at liberty are very important, right? Are very important, and they should not be touched except the individual has not harmed the law, right? So, you can see this should be the correct. So, here 1, 2 and 4, 1, 2 and 4, C. C would be correct answer of this question. Now, look at question number, this question, which article of the Constitution of India safeguards one's right to marry the person's one's choice, शादी करने का अधिकार कौन सा आर्टिकल जो है वो देता है भारतीय संविधान में? तो सिंपल है, आर्टिकल 21, राइट? आर्टिकल 21 ऐसा आर्टिकल है, बेसिकली इट इज अ मदर ऑफ ऑल राइट्स. लेट मी टेल यू, बिकॉज आर्टिकल 21 explains right to life and personal liberty. So here two things, right to life and right to liberty or personal liberty. Right, personal liberty. Now, right to life includes everything related to life, which is necessary for enjoying life. Right, for example, education, yeah. For example, eating, yeah. Individual cannot sustain without eating good food. Right, right to life includes walk, yeah. Right, now if you have personal liberty, yes, right, walk, yeah, read, yes, marry, yes, right. So if you look at article 21 would be the correct answer. Now look at the next question. Which of the following categories of fundamental rights incorporate protection against untouchability as a form of discrimination? Now, if you look at fundamental rights (FR) in India, we have 6 set of rights. First is right to equality. Second is right to freedom. Third is right against exploitation. Fourth, right to freedom of religion. Right. Then fifth is educational rights. Educational and cultural right. And sixth is right to constitutional remedy. Right to constitutional remedies. Now look at here, the question is, which of the following categories of fundamental rights incorporate protection against untouchability? Now look at where is the protection of untouchability. You know that right to equality, article 17 actually talks about abolishes untouchability. So you have to choose options accordingly, and options D would be the correct option. Right. Now question is, what is the position of right to property in India? Right to property का position क्या है इंडिया में? Legal right available to citizen only, legal rights available to any person, fundamental rights available to citizen only, neither fundamental nor not. Now, legal rights available to any person. Right to property, is a legal right available to any person. Like for example, Amazon. Amazon is MNC, but Amazon has a right to property in India, right? Or Flipkart, like Adidas, or any other company, for example, Nokia, or LG, or Samsung, right? Any multinational company have a right to property in India. So, right to property is a legal right to any person in India. So, you can see that now legal right available to citizen, no, legal rights available to any person. So, B would be correct answer. Right to property is a legal right available to any person. Now, let us move to the next question. Now, look at the next question. Right to privacy is protected under which article of the Constitution? Now, if you call right to privacy is protected under Article 21, right? Right to privacy is protected under Article 21, right? Now, the last question, let us see. We adopted parliamentary democracy based on the British model, but how does our model differ from the British model? As regard legislation, the British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. It is correct. In order to make a law, the Parliament power is limited by the Constitution itself, right? In India, matters related to the constitutionality of the amendment of an act of the Parliament are referred to the constitutional bench of the Supreme Court. Yes, it does. Now, select the correct answers using the code given below. Now, both are correct. C would be the correct answer. So, today we have done certain conceptual clarity based on the questions on fundamental rights. Tomorrow I will we will meet and we will discuss certain different issue. Probably I will discuss Parliament. See you tomorrow.